If you have decided that filing a bankruptcy is a good option for you, then we would need to determine whether you would file Chapter 7 or Chapter 13. The process and procedure is different between the two. In a Chapter 7 bankruptcy case, the process can be summarized as this. We gather a lot of information about you, and with your assistance, reduce this down to the federal forms that are required in your case. These can run anywhere from 50 to 75 pages of printed material. Once you have certified the information in these materials is correct and true to the best of your knowledge, we start the process of filing a case. Before we can file your case, you will be required to receive an outside independent credit counseling session from a government-approved credit counseling agency. Credit counseling is not a problem. It's something you have to do to receive a certificate in order to file a case, but it is not an obstacle to the filing of your case. It's just one of the tasks you have to do. After you do that and we prepare your case, we can file your case electronically. In my office, we file your case as you are sitting there and then tell you the rest of your process after we receive notification from the bankruptcy court that your case has been received. In a Chapter 7 case, what follows is very simple. You're required to do another class. This can be done online or over the telephone in debtor education. You're going to be required to submit to a 90-minute session that will tell you some basic information about how to handle your finances or the importance of saving and budgeting. This is not a matter that you pass or fail, but that just simply that you do and receive a certificate. It's important that you pay attention to this education. It does have some very good help for you in how to manage your finances in the future. After that, there's one main task that you have to do. You're required to attend a meeting of creditors. This will take place at the federal courthouse, generally in Greenville, Tennessee. At this meeting, it is important to remember what is going on and what is not going on. When you go to the meeting of creditors at the federal courthouse, you are not going to court. You are not appearing in a courtroom. You are not appearing in front of a judge. Indeed, for most clients, they never see the bankruptcy judge in the course of their case. But they do have to attend the meeting of creditors. Your meeting of creditors takes place on the first floor of the federal courthouse, in what I call the basement. You will attend this meeting along with a lot of other people who have filed a bankruptcy case. At this meeting, your creditors are invited to come. However, very few creditors actually show up at these meetings, and in your case, we would be able to predict whether or not any particular creditor you owe would bother to come to the meeting. As a rule, very few creditors ever show up, and we may spend hours in these meetings without a single creditor making an appearance. What you're there for is for me and you to sit down across the table from an appointed attorney called the bankruptcy trustee. This person's job is to review the information we have submitted and see if it looks like you have too many assets. Remember at the introduction I said that you cannot remain wealthy if you want to discharge debts. This is the person who decides if you have any surplus wealth, and it is their job to sell these items and raise money to pay your creditors. In most cases, there is no surplus wealth to be distributed to creditors. But if you have exposed assets, you would need to have a consultation with us to determine how to handle that particular problem. For most of my clients, this meeting and this interview by this attorney is relatively brief. Almost all of my cases, the interview is less than 10 minutes long and sometimes as little as 5 to 6 minutes. It is not a thorough interrogation by some attorney of your financial condition, but it is a review of the information we have submitted, which you have sworn to as being true and correct. So this attorney takes your paperwork at face value and will make a determination whether or not you appear to have a surplus of assets they would need to sell. If they decide there are no such assets to sell, then they file papers that called an abandonment, and that means that your assets are all yours again and will not be sold in your bankruptcy case.